97.3 City FM. Relevant radio, always.
The evidence before the court. A court will deliver judgment based on the evidence before it. And in doing that, they have to determine whether or not the right questions have been asked, whether or not the right responses have been elicited, whether or not, therefore, the case of the petitioner or the plaintiff is still strong or weak. All that is for the court to determine. And therefore, I cannot answer your question. If I answer and I answer truthfully, if I tell you, then I will be taking away the work of the court. And the rules don't permit it. And that will be putting me right in the path of committing contempt. You recall that the circulator started cross-examination but completed after him, then we had the counsel for Petition, Mr. Petition, who finished before midday yesterday. Thereafter, Mr. Tsikata took up the mantle and has been cross-examining the whole day. There is no indication that he's completed. The court has adjourned the matter for a second continuation. That decision that is the would I not? You want to go in there? The court has the right of review, and therefore the political authority has the right to that power is provided in the contrary to what the law provides, that there will be no review to judicial issues. It's quite clear that the rules of the then you have to do whether or not the courts can work. Certain categories of businesses can work. Essential services, shops that do can work. But other businesses, including petition, cannot unless a dispensation is sought from the executive. The court, however, also said that ordinary such matters ought to be left to the Chief Justice, but the law is what it takes, not to be able to apply as it takes. So clearly, although the law said that in the provincial petitions, the court who sits on weekends and public holidays, this decision seems to say otherwise, because it's a business and it is not within the category of businesses that are exempted for working on public holidays, which cannot work unless it's given the dispensation by the chief executive. I'm a lawyer and I work with the law, so I have to work with the law. It's not a matter of happiness, it's a matter of whether or not the law is being applied. And it's the Supreme Court, which is the highest court of this that says that this is how the law should look. It's acceptable to me.
Yes. I'm online. Got it. Well, a full day. Thank you. I will quickly mention what happened very early in the morning, where a Supreme Court panel sat and the Bernard Mona case. And I think that it's a landmark case in which two key positions were rolled out by the Supreme Court. First, related to the reviewability of the decision of the what do you call it? Of this panel. I mean, potential of this the petition panel. To read what does that mean? If this court, for instance, makes a ruling or a decision at the end of the case, will it be open to anybody to apply for a review? CI 75 says appear to say no. But today, the Supreme Court, in the Benamuna case, came out with a clear interpretation that says that if CI 75 is saying that, then CI 75 to that extent is unconstitutional. That. Secondly, related to the application, whether a public holiday, the court could be compelled to sit. And the court came out with a decision that, yes, on a public holiday, the court must observe the law, and the courts cannot sit on a public holiday. But quickly, I want to mention that this is a very serious matter for the NDC people, because in 2008, in fact, 2008, immediately after the decision, and then by on the 1st of January, it's a statutory public holiday. The NPP, led by lawyer Thatcher, went to court on a public holiday, and he invoked the court and got the court to sit to try to overturn the decision of the people that had, invested the powers in the then President Mills. It's a very serious matter. The two of us here, myself, had to dash to Hakim Swedro High Court on the 25th of December. It was a public holiday, 2008. Because some of the NBC executives had been arrested on a public holiday, 25th, and we said it was unconstitutional. Our pleas went to naught. 5 years later, this Supreme Court has come out clearly to say that the court has no power to sit on a public holiday. And we feel very vindicated, and we think that this is a tribute. We want to do that as a tribute to those people who were languished in jail for more than 10 days. And this unconstitutional act in 2008, when the court sat on a public holiday, when they knew that they ought not to sit. But back to today's main session. Who said that, as I said, Mr. Tsatsu Tsikata probed further, and as far as I'm concerned, totally sank Dr. Baumia. He had to come out to make several admissions relating to what I might term exhibit irregularities. I mean, it was quite clear that the exhibits that the defendant and they rely on have substantial, defects and could not be properly relied upon. Of course, I would marry to say it will be the court that will decide on that. But they made several, they made a lot of admissions. They abandoned quite a number of the positions. But they want to mention that one of the, particularly the last admission that Dr. Baumia made, sounded rather sad and rather belated. That today, he said that the allegation on the super law, that story, you remember that some Chinese and Israelis were transmogrifying the result, that is changing the result as they come from police station and turning them in favor of President Muhammad. He said that allegation, formally, he said they've abandoned it, they are not pursuing it. But why it's sad is that as a result of those allegations, there was a near route, and also people were attacked. You get me? That's how far we can go with rumors. And that's why we should be careful about allegations and what not we make. I keep saying that there's a difference between allegation and there's a difference between evidence. This allegation of superlock transmogrification of the results, it's in the petitioners' affidavit. It is their case. They rely on it. 9 days or so into the trial, they say they've abandoned it. They are entitled to abandon it, but I'm just saying that we should all, as a people, we can learn that, and what can lead to very dangerous consequences for people and the security of the state. So I think that, as I said, we are on track, obviously. Our business, Tsatsu Tsikata's business here, is to demolish the case of the opponent, build the case of his side, and then show that the witness is